of the Center for Human Rights, University of Pretoria. And on behalf of the Center for Human Rights, University of Pretoria, and our co-host for today's event, the NorwegianCentre for Human Rights, University of Oslo, I would like to welcome everyone to what is the second edition of the series of seminar on the domestic impact of the UN treaty system. So the first edition of this seminar was a hybrid event that was hosted in March by the Norwegian Center for Human Rights in Oslo. And today's seminar builds on the discussions in March to discuss issues around the influence of the UN treaty system in theory as well as in practice. Just to quickly say that as we move along in the conversation to our participants, please remember to type your comments and questions as you listen to our speakers for today in the chat box. And at the end of each session, we will have about 5 to 6 minutes in which we will then select the questions and comments and direct these questions to the presenters for each session. Before we move into the discussion for the session, I would like to invite the Director of the Center for Human Rights, University of Pretoria, Professor Frans Viljoen, to give his opening remarks and I guess shed some light on the Youth First project, which is the project that has the bigger, that is the big umbrella for this seminar. Prof. Frans, you may have the floor, please.
Thank you. Thank you very much, Felucio. And may I add just a brief word of welcome to all the participants, wherever you are. Good day to you. And to all our presenters, facilitators, thank you very much for joining us. Yes, let me say just a few words about this joint Utforsk project between the Center for Human Rights and the Center for Human Rights, the Norwegian Center for Human Rights. The overall title of this is Fostering Research-Based Education through Academic Mobility and Measuring the Domestic Impact of Core Human Rights Treaties. The two centers, the two co-hosts for today, have in fact been working together for quite a number of years, and this is a continuation of our interest in the domestic application of international human rights law. Now, the two centers actually share a few features. We have in common that we are both university-based centers that focus on the domestication of international human rights law. We are also both running a well-known and important human rights program. In the case of the Center for Human Rights in Pretoria, we run the Human Rights and Democratization in Africa program in partnership with a number of law faculties across the African continent. And in the case of the Norwegian Center, it runs the master's program on the theory and practice of human rights. But we are also, in a sense, siblings of the international human rights movement, and we are really brothers and sisters of an almost equal age, because the Center for Human Rights last year celebrated 35 years of its existence, and so does the Norwegian Center this year. So you could see that we are really, in a sense, very close collaborators over time. Now, this particular project is funded by the Directorate for Higher Education and Skills, and is a continuation and strengthening of our collaboration. The idea of this project really came about through discussions between Professor Gentian Zuberi from the Norwegian Center and the late Professor Christoph Heinz, the previous director of the Center for Human Rights and member of the UN Human Rights Committee and many other things. Now, they were together on that UN Human Rights Committee, and during discussions in Geneva, really forged thinking towards this project. Later on, others joined on the Norwegian Center side, Peres Jones and Bart Anders, and on the center side, I myself, and also more recently, Professor Magnus Schillander and Felucio Adegalo, our moderator for today, and others. The main goal of this project is to improve the quality of our respective master's programs, the programs I mentioned, and to enhance mobility between our students so as to work out modalities and implement those to ensure cutting-edge collaborative research in this important field. The activities that are foreseen under the project include the exchange of 10 master students, 5 incoming and 5 outgoing at each institution, short research stays of 6 academics, again 3 from each of the institutions coming and going, and then also the development of 2 joint courses, specifically in human rights methodology and around the theme of business and human rights. The other leg of the project is to develop a research project on the impact of the 9 core UN human rights treaties and 10 UN treaty bodies in South Africa and in Norway, and to develop an online database that will allow continuation and continuous tracking of domestic impact. Now, as you know, myself and the late Professor Haynes had previously embarked on a study of 20 countries and looking at the impact of the UN human rights treaties in those 20 countries. We have done, and we've embarked on an update, if you like, a 20 years plus study, which we talked about briefly the previous time on 9 March, as Felucio indicated. And we hope in the course of the year that this will be brought to completion and will appear on your bookshelves, even if only electronically. Now, as part of the mobilities, 2 of our students from the Center for Human Rights are currently in Oslo. They are completing the master mini dissertations, and one of our PhD doctoral candidates, Felucio, had already spent some time and is on his way back from Oslo, even as we speak, as it were. So we hope that the research project will really culminate in all the objectives that it has set for itself. Ultimately, it's going to last until 2025, with a big international conference taking place in that year. And in addition to the activities that had been mentioned, we will see further involvement of our master students in developing research and publication. The issue of impact is extremely topical in the field of human rights, and that is the interest of also in increasingly so on the issues of international policy making and in regional international organizations, the African Union, the United Nations. The issue has really shifted, as we all know, from standard setting to deep and abiding concern for the actual impact of these standards. So we hope that collectively all the activities within the project will contribute to a better understanding and a better realization of rights at that level. So sum up, this project started slightly late, but from its take-off, it will run until July 2025, and it essentially has 3 pillars: yearly impact seminars, academic exchange, mobility between students and staff of the 2 institutions, and then the joint development of the curricula around a human rights methodology and business and human rights course. So thank you very much for joining us for work in progress, as it were, which are part of this joint Utforsk project. We thank you for your interest, and we are sure that as the project progresses, there will be many opportunities for further collaboration and involvement. Thank you very much again to each of you for being here, and back to you, Felucio.
Thank you very much, Prof. And thanks for setting us off on a very good precedent by sticking to time. Our next speaker is Professor Gentian Ziberi. Professor Gentian Ziberi is a professor of international law and human rights at the NorwegianCentre for Human Rights, University of Oslo. And as we have all listened to Prof. Francis, also a part of this project. And Professor Ziberi is a member of the UN Human Rights Committee and also a member of the Permanent Court of Arbitration, The Hague, in the Netherlands. He has done a lot of research, he has published, and he has taught in areas of international human rights law, international humanitarian law, international criminal law, and public international law at various universities in the Netherlands, Albania, China, the US, Kosovo, and Norway. Now, from his rich experience as an academician and a member of the UN Human Rights Committee, Professor Gentian Ziberi will be sharing his reflections on the impact of the UN Human Rights Committee with us. Professor Zibiri, you may take the floor, please.
Thank you very much. Thank you very much, dear Falusa, dear Franz, for those kind words of introduction, and Franz for the important introduction of the project and our cooperation that I hope that will continue for many years way beyond 2025. As it is usual with such presentations, the more you think about things and the more time runs, then you have to adjust. So in fact, what I would like to share with you today is some general reflections on studying the impact of the Human Rights Committee at the domestic level, rather than the impact itself. So what I'll try to do in the short time available, I'll try to introduce very briefly the topic of the impact of the core human rights treaties and mechanism at domestic level, then say a little bit about the theory of change and methodology that helps to track the effect of the practice of the Human Rights Committee, and by analogy of other UN human rights treaty bodies, I'll use the acronym UNTBs, and maybe at the very end, very quickly provide a few examples of the impact of the committee at the domestic level before concluding. Now, why do we speak about impact to start with? There has been a recurring concern and criticism that has accompanied international human rights law more generally, and human rights enforcement mechanisms more specifically, whether they have any impact at the domestic level. So why do we have them? What, in a sense, justifies their existence? And the debate around this issue has been reflected within the UN system in several initiatives to improve the effectiveness of the UN treaty bodies, and in scholarship in studies concerning their impact. And the Pretoria UN Human Rights Treaty System Impact Study, which is run by the Center for Human Rights, is, I think, an excellent example of those in-depth studies, as it were, with the 2002 published study of 20 countries, and what we expect now, by the end of this year, hopefully, the new study or a continuation of that after 20 years. Now, there are, of course, other studies that have looked into these issues. And these studies are important because without understanding the extent to which the activity of UNTBs helps to bring about the improvement of human rights situation domestically, it's impossible to ensure that this system will meet the challenges of the 21st century, and there are many. Now, the concept of impact has many dimensions and can be approached from a variety of angles. Here, for me, impact is connected to the effect that practice of the committee and UNTBs more generally has at the domestic level. And since the cause-effect relationship is difficult to prove, we have to adopt a correlation as a basis, meaning that a plausible connection will need to be shown between the practice of the committee or UNTBs and the legislative, administrative, or other changes affected at the domestic levels. UNTBs provide well-established mechanisms for periodical oversight and engagement with member states, and they have contributed significantly to the progressive development of international human rights law through their activities. Here I have to note that the multiplication of human rights mechanisms and monitoring procedures with the special procedures of the Human Rights Council and the Universal Periodic Review make it even more difficult to discern where the impetus for change came from. But that said, here I'm not going to look into that, but I'm just going to look at the Human Rights Committee and the UNTBs. Now, moving on to the theory of change and methodology for detecting impact. How does change happen, or rather, how it is brought about? Here, a theory of change in our case would basically focus on the practice of the treaty bodies and how that contributes through a chain of early and intermediate outcomes to the intended result, which is basically the improvement of domestic human rights situation. There are lots of approaches and studies on institutional, instrumental, informed by political sciences and other fields that have become quite prominent, and with more attention paid to aspects of legitimacy and effectiveness of the work of human rights mechanisms. And this shift coincides methodologically with an increased focus on empiricism, quantification of human rights, and proliferation of different indexes and measurements. And the main theories of change concerning the impact of international human rights are the domestic mobilization thesis with a bottom-up focus, the boomerang thesis with a top-down focus, and a more recent theory, the experimentalist approach, which combines these bottom-up and top-down approaches. When it comes to the effect of UN treaty bodies at the domestic level, these theories can partially explain the changes that have occurred as a result of the periodic engagement between member states and the UNTBs. And this engagement occurs through the three main methods of work: the state reporting procedure, which is more systematic, and periodical individual communications, and general comments and recommendations. And here I have to add that this engagement between the treaty bodies and member states can happen along the lines of alignment, implicit or explicit, avoidance, or confrontation. How do we glean that impact? Well, we can look at the relevant documents available in the website of the Office of the High Commissioner for Human Rights, concluding observations, follow-up reports to concluding observations, decisions on individual communications, follow-up reports to them, and specific statements by UN treaty bodies. And besides what is produced by the UN treaty bodies with the support of the Secretariat, submissions by national human rights institutions, NGOs, civil society, UN agencies, individuals and their lawyers are important in identifying positive or negative changes over time. And at the domestic level, we will have to look, of course, at the activity of the three main branches of the government: if you want, executive, legislative, and the judiciary. Adoption of new laws or amendments, national strategies and policies accompanied by dedicated budgets and indicators, change of administrative and other practices, training for the legal profession and other law enforcement agencies, and budgetary allocations for NHRIs and civil society. Now, of course, there are a number of caveats necessary here, and Faluso, you'll have to tell me how much time I have, at least when I have a couple of minutes, just to give me a signal.
You have 2 more minutes.
2 more minutes. Okay, then I think I'll immediately then go, instead of the caveats, I'll probably go directly to the impact of the Human Rights Committee. Very quickly, in terms of the methodology, of course, we have the concluding observations that are adopted. We have the cases, individual cases. We have also the follow-up reports. And when it comes to the state reporting procedure, I think what can be said here is that the committee issues the concluding observations by first listing positive developments. So there you can see what has been, if you want, the purported impact of the engagement with the committee. And then the committee has this interesting practice of selecting 3 recommendations for follow-up. And I think we can glean some of the impact of that work by looking at the grades that are given by the committee from A to E. And A and B grades would be those that would denote this positive impact, I would say. And C, D, and E grades are those where there would be problematic, that the state has not really reacted to the work of the committee. When it comes to individual cases, of course, the committee keeps the dialogue open with states until a satisfactory implementation has taken place, and gives the states 180 days to report back to the committee, to tell the committee about the steps taken to give effect to remedies indicated. Very quickly, general comments before I move on to some concluding remarks. The impact of general comments can be seen as connected both to the practice of the committee more generally, references to them in concluding observations, decisions, individual communications, but also to the progressive development of international human rights law and the broader impact in references to this practice by decisions, regional courts and commissions, as well as high domestic courts. And I have to say that here some of the more recent general comments on Article 9, liberty and security of person, right to life, and general comment 37 on the right to peaceful assembly have broken some new ground. Now, to conclude, expectations on the UN treaty bodies are quite high, and if I can use the proverbial 5 loaves and 2 fish miracle, expected to change the human rights situation radically, but I'm afraid that UN treaty bodies cannot perform such miracles. Still, in a limited context, in a context of limited enforcement options at the international level, the Committee and other UN treaty bodies are an important tool for engaging with states to improve the human rights situation on the ground. Here, the COVID-19 pandemic has aggravated the challenges facing the UN treaty body system, but hopefully some of those issues can be addressed through the UN treaty bodies strengthening process 2020. The UN treaty bodies have strategic tools that would facilitate the constructive dialogue with states, independence, knowledge, geographical representation of various world cultures and civilization, and unleashing their potential, I think, would help diffuse polemics and politicization of human rights. As researchers, we can play our part to uncover the impact and to show how the practice of treaty bodies helps change the situation on the ground while critically assessing that practice where necessary. Thank you very much.
Thank you very much, Professor Zuberi. We would see if there are questions or comments at the end of this session for you. Our next speaker is also coming from the NorwegianCentre for Human Rights. Her name is Julie Arnesen. She's an advisor at the International Department of the NorwegianCentre for Human Rights, University of Oslo. As an advisor at the NorwegianCentre, she has worked on projects around freedom of religion and belief, particularly in the Middle East. And also, as part of her role as an advisor at the International Department, she has been coordinating a project that focuses on raising the bar on accountability through the Universal Periodic Review and the UN Human Rights System. And it is from this vantage position that Julie will be reflecting on the role of academia in the promotion of human rights and how the academia can contribute to a larger domestic impact of the UN treaty bodies. Julie, you may take the floor, please.
Thank you so much for the introduction, Felucio, and thank you for allowing me to share a bit of the practitioner's insight on this question on domestic impact. My reflections are, like many of the other speakers here today, I would think, not based on academic research, but rather on results and experiences from my work with certain human rights education projects. As Felucio said, I work for the International Department of the NorwegianCentre for Human Rights. And while we are a part of the university, our mandate is specifically human rights in practice. We are funded by the MFA to promote human rights, mainly through competence building, knowledge enhancement, and dialogue. And I work specifically on our projects on UN mechanisms, where we support initiatives enabling our academic partners to engage in regional and multilateral processes promoting human rights, sometimes internationally, but mainly domestically in their own communities. We are currently training scholars working within the human rights field in the functioning of the human rights mechanisms, where we provide coaching and lectures. We facilitate meetings with UN experts, often from their own countries or regions, and we invite them to observe sessions within the different treaty bodies or the Human Rights Council as well. And these efforts are, from our side, based on the notion that civil society, and in this case, academia's awareness of and engagement in the work of the UN mechanisms is vital to the realization of human rights in their communities. I mean, generally, we could say that, of course, the more well-known the recommendations from the UPR and different treaty bodies are among the population, the more likely it is that authorities are held accountable for their fulfillment or lack of fulfillment of human rights. However, by specifically including academics as our target group, we hope that this awareness, engagement, and ultimately and hopefully contribution to impact can be sort of lifted to another level. And I mean, in my world, in the development aid world, we call this training of trainers, which means that the knowledge is not just passed from one person to another, but has sort of a broader aim. And this broader aim is where we move towards the impact. And I think, speaking from a non-academic point of view, so to say, I believe it's relevant for the context to at least briefly touch upon how we view and measure impact in our projects. Because when developing and implementing our projects, we always aim for change at the community level. This means that the activities we execute, which is the outputs, should lead to a change on an individual or group level, which is the outcome. And then hopefully these outcomes will have influence sort of on a higher level, domestically, internationally, and so forth. This is the impact. So to use our UN mechanisms workshops as an example, and also just to explain a bit more about these workshops, we provide trainings, networking opportunities, and the chance to observe and take part in treaty body or UPR sessions relevant to their country in specific. And this is the output. And then the learning outcome that our participants receive from the workshop, potential dissemination of the knowledge when they return home, and contribution to, let's say, parallel reports, or even the general human rights discussion in their communities. That is the outcome. And then we have the impact, which is more difficult to measure. And the impact we aim at could be increased awareness or engagement among the population. It could be changes at the political or judicial level. Or, of course, it could be implementation of these UN recommendations. So from a development aid point of view, impact is difficult to measure because we can seldom know for sure that the detected change is really due to our efforts. And I mean, you could say that why and how this change is occurring is not as important as the fact that it is occurring, but to be able to evaluate what works and what doesn't work, and to continue then with best practices for other projects. Some form of measurement is important. Yes, so in what ways then can academics contribute to this domestic impact? How can we see and have we seen that engaging human rights scholars in our trainings and opening the doors to the UN mechanisms can lead to domestic impact? What we often see is that academics are important for social mobilization in a community. They provide research-based inputs to the constructive dialogue between the treaty body and the state party, or research-based inputs for parallel reports and other kind of documentation. And they're also vital for to the follow-up job after a treaty body review, which is often neglected in many of the countries that we work specifically with. And we see that academics are good at contributing to the domestic pressure, or at least sort of a domestic resonance to the international pressure. And of course, in addition, scholars are a part of a learning and research environment. They're good at getting their research and views out there, both to students and to other colleagues as well. And lastly, we also see that they are being listened to, perhaps more so by the government, for example, than activists and NGOs and so forth. So finally, to mention some more specific outcomes from our UN mechanisms project. A common outcome is research and dissemination of knowledge and experiences. Many participants develop course modules, learning materials, or they provide lectures on the knowledge gained. And this then, of course, contributes to spreading the knowledge. Other participants have taken active part in the implementation work of the concluding observations during a reporting cycle. Some participants have been nominated as advisors to governmental or international organs on human rights. And some have put together networks of scholars and NGOs to contribute to parallel reports, or even also the general human rights dialogue in their communities. And then lastly, I mean, many participants had just continued being what we could call insufferable watchdogs over their governments, which is just as important. So all in all, we see that scholars that are trained in and take particular interest in the functioning of the UN mechanisms become important agents of change in their communities. And I mean, with this specific project being rather young, it is difficult for me to say that these efforts lead to domestic impact, the way we see impact at least. But they do provide change on an outcome level. And we believe that by continuing to support their efforts, this will influence their communities as well in the long run. Yes. So thank you so much. Thank you for listening.
Thank you very much, Julie. I thank you for the presentation. We will see if there are questions and comments for you. So the next item on our agenda is just reflections on the online database, which I think Professor Franz and Professor Ziberi has spoken about, which is a work in progress by the Center for Human Rights. So I will quickly take us through what this project is all about and what we are trying to do and what we plan to do. So the database on the impact of the UN treaty system is a comprehensive and a long-term research project that aim to increase the visibility of the United Nations treaty system on the ground. And the core goal of this database is to facilitate, in a sense, a better understanding of the dynamics that are involved in the processes through which UN Human Rights Treaty system, which is the core 9 UN Human Rights treaties, as well as the substantive protocols and also the outputs of the jurisprudence of the UN treaty bodies, the extent to which we can say these are some of the impacts that we can see for this treaty system. So the long-term goal, it's a long-term project, and the long-term goal is to capture the impact of the UN treaty system in about 193 countries. And I think building on what Julia said about how problematic the concept of impact can be in this space, I would just want to quickly say, then what do we mean by domestic impact as envisaged under the, this project, the online database? So for us, we conceptualize impact as some sort of direct evidence, in a sense, that material impact, if you like, tangible effect that in a way you can attribute to the UN treaty system. And not necessarily attribution, but in a sense, you can see the role that the UN treaty system has played in this evidence of impact. The key thing that I would really want to spend a bit of time explaining for us now is how do we then populate a database that intends to capture impact of the UN treaty system in about 193 countries. We have adopted a couple of approaches so far. And of course, our first source of inspiration for capturing impact under the database is the book that has been mentioned by Prof. Ens on the UN treaty system, which gives us some information about the impact of the UN treaty system in 20 countries and over a long period of time, because the first edition of that book was in 2000, and the second edition will be coming out hopefully before the end of the year. Now, in addition to this, we have developed partnership with academic institutions. And in this regard, we engage students in our partners' different academic program to generate information that can be used to populate the database. And some of the academic institutions that we have worked with so far include the Geneva Academy, the Bristol University, and the Kathmandu School of Law in Nepal. We will be seeking to extend our partnership with other academic institutions this coming year. And maybe this is a short call to some of us who are with us on this seminar. If your academic institution is interested, you can please reach out to us. And of course, as Prof. Franz has said when he was talking about the center as an academic institution is an academic institution in itself. And in this regard, we have, in this year, we have integrated research on the online database into the master's program on human rights and democratization in Africa as a means of populating the database. And of course, our students for this year have worked on a couple of African countries. And so what we also try to do is all of the students that have worked on this database, when we go live, they will all be acknowledged with regards to the respective countries and the treaties that they've worked on. And I suppose a further incentive for our students is that they can then engage in academic analysis of some of the information that they have gathered in the course of working on the database. And of course, we will be listening shortly to how this can also be really beneficial from one of the former students that have worked on this project. The other source that we are also trying to work on is to collaborate with NGOs and some sort of crowdsourcing through independent researchers. And in this regard, we are encouraging independent researchers who are working on this field to please share information with us so that we can upload. And also NGOs and victims of human rights violation that have information as to how the UN treaty system has played a role in their human rights situation can also reach out to us, and we welcome other suggestions and collaboration with all actors that are working on this field. Now, for practical purposes, of course, how do we then intend to get information from the potential contributors that we are working with? Now, in order for us to do this, we have developed a template, which I would still call a work in progress, but I think we are in a good position now. So the templates consist of a set of tables in the form of spreadsheet. And this template, in a sense, I just want to share my screen so that you can see the template. So this is just an example of what the template looks like for South Africa across the treaties. So in a sense, the template is a set of tables, and it covers the 9 core UN human rights treaties and the substantive protocol. And we have identified 7 actors that we intend to capture, through which we intend to capture the impact of the UN treaty system. And you can see on my screen what this would look like. But just to save time, I think I'll just leave it there. And if you are really interested in working with us on this, you can reach out to me. But for now, I would like to invite one of our former students that have worked with us on this project, Ms. Ansari Fegana, who is a graduate of the, I'm just going to stop sharing my screen now. So, she worked on the project, the Harvard Law School Advocate Dialogue, and sharing her experience on the project. Hi, Fe, how are you?
Hi, I'm good. How are you?
I'm good, thank you. And thanks for joining us. So how did you get to work on the project, and what was your role on the project?
Sure. Thank you so much for inviting me. Really happy to be here. I was an LLM student at Harvard Law School starting fall 2020. And that's when there's different student practice organizations that are present at Harvard, and you can get involved in any one of those at the law school. And one of those is the Harvard Law School Advocates for Human Rights. And it's a largely student-led student practice organization, and they take on different projects. And then whoever wants to become a team member of those, they can sort of join and then, contribute to that project. So that's what I wanted to get involved in, and through that organization is how I found out about this particular project. And they were taking on this project, and then they had a call for people who would be interested in contributing to it. So in the fall of 2020, I started out as a team member of that project, and then all the work that you've been describing on how we sort of worked on evidence and collecting evidence on the impact of treaty bodies. So that's what I started doing as a team member. And then because there was COVID and everything was online, I took a leave of absence for about 1 semester. And that's when I started working on this project independently. So as an independent researcher. So for 1 semester, then I worked on it as an independent researcher. And then when I rejoined Harvard back to complete my degree, that's when I became a team lead for this project. And then I led a team of around 7 to 8 Harvard Law students. And then we sort of worked on different countries and documenting the impact of the treaty bodies on different countries. So I have been involved as a team member, as an independent researcher, and team lead. So I do have that kind of an experience, and it has been a wonderful experience so far.
Okay, so you said it has been a wonderful experience so far. I suppose I don't need to ask you about how your personal experience has been, but have you found this project useful, after your master's program?
I'm sorry, could you repeat that? You're cutting out a little bit.
Oh, okay, sorry about that. I was saying, how have you found this project useful for you after you completed your master's program?
Oh, sure. It's actually been really, really good for me. So I graduated from Harvard just this January. And ever since, of course, I've been interested in human rights law, international human rights law. I wanted to do something in relation to that and gender equality. And that's when I applied to this organization called Musawa. It's a global movement working for Muslim family law reform throughout the world, and wherever, there are laws in place that are sort of unequal, Muslim family laws in particular. So when I applied for this, that's when it was a position of an international advocacy program officer. So it involved basically the kind of work that Julie just now was talking about, on how, you submit thematic reports before CEDAW, before other, treaty bodies, and then as a nonprofit organization. So this was the kind of work that I wanted to do on my own as well. And this project is exactly what gave me that experience. And that really, really helped me in joining this organization and being able to do the work that I do, because I already had that knowledge from the project. So, I personally am based in Pakistan and I'm from Pakistan. So I had also worked on Pakistan as a country for the project. And then what we did was, track all of the mentions of CEDAW and everything else that I will be highlighting later on in my presentation. But that's the kind of work that really helped me understand how treaty bodies work, how the reporting mechanisms work, And that really helped me in joining this organization. And now we're doing pretty much the same kind of work that, the kind of impact that Julie mentioned, we're hoping to get out of it, submitting shadow reports, getting NGOs together as a network, and then getting them to submit shadow reports and, building their capacity to do that. So I think that this project has been really useful in helping me do that kind of work and even get that opportunity in the first place.
Thank you. So just on a concluding note now, what would be your advice for students and other independent researchers that may be interested in working in the project?
Sure. So I would say definitely get involved if you're interested in, international human rights law generally and this treaty body impact study specifically. But also, since Feluso, you mentioned that the database is sort of a work in progress, I would really like for, upcoming students to also contribute to how they may be able to change that database or the format of the database in accordance with what's needed and what's not, and what's important and what's not. So that is something that I would definitely encourage any students or independent researchers involved to get more involved in and contribute towards. So yeah, thank you.
Thank you very much, Faye, for sharing your experience with working on the project. So that brings us officially to the end of the first session. But I think before we leave this session, I see in the chat box that there seems to be a question for, I think this is for Professor Ziberi, that you have talked about bottom up and top down. What do you foresee as bottom up, or rather contributions from domestic level to UN treaty bodies, aside from bringing in complaints? Professor Ziberi, do you want to respond to that?
Thank you, Feluso. Yes, I can tie that question with the question asked by Akinaga on the Q&A about the role of UN treaty bodies in empowering domestic mobilization, and start by saying that the UN human rights treaty bodies provide a venue for the engagement with the member states by allowing for the provision of alternative reports, the submission of individual cases, and also provide an opportunity to submit views, the views of various domestic actors on general comments that are being prepared or general recommendations. So in that sense, then I think that is an important thing to have that process, to have that engagement. Then of course, if you want, the effect of that engagement will very much depend on various factors. Not all countries have a vibrant civil society because of various reasons, because in some authoritarian countries, the civic space has been curtailed, has shrunk actually quite a lot. So in that sense, then having that engagement at the international level provides at least a venue to raise those concerns. There are also instances of what has been called strategic litigation, where certain cases are brought before the committee in order to raise the profile of a particular problem. It might be a systematic problem in the country. That is also important. But the follow-up to the concluding observation, the follow-up to the decisions on these individual communications is very important. And there the committee, in a sense, needs or relies on this information provided by the domestic actors to try to keep the state to account. Here I have to say that we're also reliant very much on the goodwill of the states, and overall states engage with the committee, but there are also instances of states that do not engage sufficiently. So overall, I would say there is a good engagement, but the COVID-19 pandemic has created some problems, I think, in that regard as well. And my final remark here would be to relate this engagement with the UN Treaty Bodies Review 2020, which is being concluded slowly. And I think we need to keep those channels open and to try to engage the domestic actors, NGOs, civil society, academics, legal clinics, all of these various forms to allow them to engage with the committees, with the UN treaty bodies. that is very important, I think, because we rely on the information that is provided through these channels in our constructive dialogues with the states. I'll leave it at that. Thank you.
Thank you very much, Prof. Zuberi. But I think there's one more question here for you on how theory of change contributes for the domestic impact of the UN treaty system. Would you want to address that?
Very quickly, actually, only 3 or 4 sentences. The theory of change is related to how we think about change. How does change come about? And because we want our work to have impact on the domestic level, we want our work to be used, then the theory of change is used as a framework, if you want, to inform our work so that our work has the best possible impact, and also to avoid any unintended consequences of that work. So that's why this theory of change and thinking about this and thinking about how we go about our work, I think, is quite important. And here we also need the work of researchers or academics, as Julie was mentioned just a moment ago, to try to look into this, to try to actually uncover the impact of the UN human rights treaty bodies. And that's also the work that Professor Viljoen and others involved in that book that is forthcoming. And I'm looking very much forward to that. Thanks.
Thank you very much, Prof. Zuberi. And just to now go to Prof. Viljoen. Prof, I think this question is somewhere for you. So one of our participants said states have been ratifying various human rights treaties at regional and international level for years without making a real change at national level, obviously. Now, could we consider the ratification and could we consider the ratification and a mere incorporation of human rights standards at national laws, for example, in the Constitution, as impact?
Thank you, Felucia, and thank you for the question. And I think it's a broad and an unanswered question that will intrigue us for a long time. But I think I would intuitively answer, really, it's about the temporal scope that you also apply as you analyze or think about impact. You know, how long, do you look at, what period of time? Yes, clearly, if we just look at, the adoption of a constitution and the time frame, that may not be yet translated to anything that, maybe seen as tangible or linked to the treaty itself. But it's about, over time, how the constitutional incorporation is an anchor that, translates over time. One assumes, one anticipates, and it does play out in practice, at least in a number of countries, into legislation, into practice. It's not necessarily the case, but if there are other factors, so I would say alone, it is not obviously going to be a sufficient factor, but it is a factor that if other societal factors come into play as well, can serve as an anchor for much broader impact within society. Yes, clearly, it's a small matter of constitutional anchorage, if you like, of the treaty. In itself, it cannot stand as impact, but it is an anchor that often over time enhances and radiates impact in the legal system and beyond the legal system, strictly speaking. That's kind of what our analyses also indicate. Thank you.
Thank you very much, Prof. Before we move to our next session, I see there are a couple of inquiries, if I could put it that way, about participating in the projects that we've spoken about. You can always do that, please, by just sending an email to me. I've put my email in the chat box for everyone. And just send an email indicating your interest, and we would see what the best arrangement could be. Could be from an academic institution. If you're a student, it doesn't have to be UP students alone. I see someone was asking about non-UP students. And also you can participate as an independent researcher. So we will figure that out. And I guess maybe Julie as well can just share email if someone wants to, see how they can be involved in the project that you are doing at the Norwegian Center for Human Rights. I think, like Prof. Ziberi said, it's quite an important one for academics. Now, thank you very much for staying with us this far. And now we will move to the other segment now. So we're done with the general reflections on domestic impact. This second session will be focusing on some general thematic discussion on the domestic impact of the UN treaty system. And we will have doctoral researchers and master students from predominantly, of course, the two institutions that are involved in this seminar. And we will then have our first speaker for today, for this session, sorry. So our first speaker is Benson Shakaya, and Benson is a PhD researcher and tutor at the University of Pretoria. And he holds a Master's of Philosophy degree, and he has had several positions, including working as Regional Advocacy Manager for the Network of African National Human Rights Institution and Program Advisor at the Kenya Human Rights Commission. Benson will be talking to us now about the impact of the United Nations treaty system in the development and diffusion of human rights norms, as well as implementation of these norms as it relates to sexual and reproductive rights. Benson, you may take the floor, please.
Thank you very much, Foluso, for this opportunity. As you've heard, my name is Benson Chakaya Atonga. I'm a doctorate candidate. I'll take you through the impact of UN Human Rights Treaty with the context of Kenya. It is actually a foregone conclusion that there are traces of impact in terms of protection and promotion of human rights at domestic level. If you allow me, I'll share with you my screen. I have a PowerPoint presentation just to guide me through. Just a moment. All right, I don't know if you are able to see my screen.
Yes, Benson, we can see your screen.
All right, thank you so much. The Universal Declaration of Human Rights and its core international human rights treaties actually play a role in guiding national, legal, and political systems, as we will see later in this presentation. The UN Human Rights Treaty system actually establishes and interprets human rights standards through the development of general comments, and I believe we all understand what general comments are. They are actually guidelines and interpretive guidelines for national or domestic level legal systems to be able to apply or implement some of the treaty obligations. We also have concluding observations on periodic state reviews, which are also very critical in ensuring that states comply to treaty obligations. We have periodic reviews by the Human Rights Council, the committees, different committees of different treaty bodies. We also have state inquiries where there are country-specific inquiries that allow treaty bodies to both investigate allegations of serious or grave or systematic violation of human rights by states, while also there are individual complaints. These are also very important in terms of ensuring that I know they give actually meaning to human rights in treaties, as embedded in treaties that individuals can be able to approach and forward their complaints of human rights violation. It's important for me to also highlight to you before delving into the details of the Kenyan legal and political system arrangement or the architecture, that we have a constitution that actually has been praised to be one of the most transformative constitutions in the region. And this constitution actually brought into tiers of government, that we have a national government, and then we have devolved units, 47 devolved units that are semi-autonomous. This was actually to ensure that power is dispersed to the local levels, and also to curtail misuse of power. So we have an executive that is obviously headed by the president, with the head of state and then also head of government. We have a legislative power that is vested exclusively in parliament, where we have bicameral house. We have the National Assembly, and then we have the Senate. We have an independent judiciary that is independent from the legislature, and then also executive. The most specific question for our discussion today is to find out whether Kenya is a monist or is a dualist state. This is very important in terms of discussing the UN human rights treaties, because it gives way for us to be able to domesticate and the procedure that we use. And then depending whether it is a monist or a dualist, it also quickens the inclusion of international law into the domestic legal system. So one article is very important for us, and this is an article within the Constitution. That is Article 2.5 and Article 2.6 of the Constitution of Kenya 2010. This is what is entailed in the Constitution, that the Constitution says that any law, including customary law, that is inconsistent with the Constitution is void to the extent of inconsistency, and any omission in contravention of the Constitution is invalid. This is also very important, that the general rule of international law shall form part of the law of Kenya. Any treaty or convention ratified by Kenya shall form part of the law of Kenya under this Constitution. So all the treaties that Kenya has ratified, some of them are listed here, they form part of the Kenyan law. Before the new Constitution 2010, that was not the case, because you needed to have a legislation that will be discussed in Parliament before that becomes part of Kenyan law. But for now, our judiciary can easily quote international law as part of Kenyan laws. So most specifically, if you're looking at the impact of the UN treaty body systems, we are looking at the way, while we were drafting the Constitution, how some aspects, and in this regard, right to sexual and reproductive health, was incorporated in the Constitution. We see a lot of borrowing directly from some of the UN human rights treaty mechanism. For example, when you look at the constitutional provision on health, you will find out that the International Covenant on Economic, Social, and Cultural Rights played a key role in terms of modeling that provision, because it has been modeled along Article 12, that the International Covenant on Economic, Social, and Cultural Rights is reflected within the Constitution. The other aspects that we can as well point out as to have been, gotten from the international human rights treaty body mechanisms is the non-discrimination, Article 27, that has played transformational role in the Kenyan landscape in terms of ensuring that there is no discrimination, and in terms of drafting the non-discrimination Article 27, we find out that the Kenyan Constitution, as it is right now, it promotes both formal and substantive equality. This is moving away from the previous constitution that did not. It only promoted, formal equality without regard to the historical injustices whereby certain social groupings were left out of the state's, social, political, and economic rights life. So we find out that there is a lot of borrowing, or the drafters of this article, there's a lot of borrowing from the United Nations human rights treaties to ensure that there is also substantive equality, whereby you're trying to redress some of the historical injustices or marginalization of certain groups, particularly women, ensuring that they are also part of the nation state. If I talk more about the impact, you will find out that in Article 27, Part C, you'll find out that we had a lot that was put in place. For example, affirmative action, whereby certain groups were actually given more opportunities to ensure that we are addressing their marginalization. For example, we had creation of institutions that would specifically deal with issues of ensuring that those marginalized, or those communities or persons that live on the margins or the peripheral of the society also are brought into the center. For example, we had positions that have been set aside, for women, for persons with disability. We had institutions that would specifically look at issues to do with persons with disability. We had affirmative action, setting aside political seats, for example, for women, for marginalized communities. We had a 2/3 gender rule. These are things that were not there in the previous constitution, but they were informed by the United Nations Treaty body mechanisms. We also had a very important, article that also was informed by the same in terms of, implementing the expanded Bill of Rights that was included in the Constitution. That is Article 21, and it has the following, provisions. As you can see, I'll share with you the presentation. The other also very important aspect, and that we can also say that could qualify to be the impact.
Benson, I'm sorry to interrupt. Just to notify you that you have 3 minutes.
Thank you so much. We are also looking at interpretation of human rights law, particularly by the courts in Kenya. We have seen a lot of impact of the international human rights treaty bodies in terms of providing, guidance to judges who are adjudicating, human rights cases, public interest litigation that go to court. We have seen them, quote the Covenant on Economic, Social, and Cultural Rights. For example, the General Comment number 14, General Comment number 22. It was very instrumental, for example, in the High Court case of Kenya, that where it relied on the general comment number 14 to make a decision in the case of Awori Olile versus the Attorney General of Kenya and 4 others, whereby, you know, it outlawed a situation whereby you find whenever you visit an hospital and you're not able to pay, you are actually detained, and it found that as illegal and, you know, a violation of human rights. There are other cases, like recent cases, whereby there's a lot of citing of the UN international human rights bodies. For example, there's a recent case in March this year that there was a lot of citing. And then there are also other cases that I have not mentioned here. We have had many concluding observations that have been issued to Kenya. Some of them have been implemented and, you know, transformed, you know, lives of Kenyan. They have even affected, you know, the policy and even practice. For example, there was a case that a case of the intersex community. As we speak right now, there was a lot of borrowing from the UN Human Rights Council by the National Commission on Human Rights, which was an amicus in the case, but also was in the lead in terms of coming up with policies to ensure that the intersex community is also provided for in Kenyan policies. So we find that in concluding, I would say that there is a lot that the Kenyan legal and political landscape has borrowed, and it has created impact that can easily be seen and can easily be traced back to the UN human rights mechanisms. Thank you.
Thank you very much, Benson, for your presentation. You may stop sharing your screen now. Thank you. And we will then move to our second speaker for this session. Our second speaker for this session is Eva Abugabe, and Eva is an integrated social developer. I mean, this shows us how multidisciplinary this conversation is. And she's an integrated social developer with over 5 years working experience. Eva is currently a master's student of the LLM at the Center for Human Rights on Human Rights and Democratization in Africa. And she's currently writing her research on assessing the domestic impact of international human rights law in the prevention of violence against women in Ghana. Now, Eva will be speaking to us today using Ghana as a case study about the domestic impact of international treaties in the prevention of violence against women in Africa. Eva, you may take the floor, please.
Good afternoon to everyone, and I stand on the protocols that were already observed to present my feedback as already highlighted by Folusho. Permit me to share my screen with you. Right. Also, I will skip certain areas, but I'll briefly touch on why this research is very important in the case of Ghana. It's known by the UN that at least 1 in 4 countries do not have laws on preventing violence against women or protecting women. And in the case of Ghana, we have signed both the CEDAW and then the protocol, which also acknowledges the girl child as part of women. So in instances where it's necessary, the CRC and the African Children's Charter would be cited. But why is preventing violence against women very important? Statistically, over a period of time, we have noticed that there are increasing cases of violence against women in times of defilement, conflict, and what have you. So you can see from what I'm sharing recently. Then what even happened is that in 2020, due to the COVID, all these cases exacerbated to the extent that 44 cases of DV, domestic violence, in just 4 lockdown areas. There are about 50 female killings as well. And we've had about 10% injured women and 10% dead children during the pandemic. Also, I'll move briefly to say that in terms of the rural to urban population, rural girls are more prone to violence than urban population. And also in terms of urban women to rural, there are more rural women who are exposed to violence, especially female genital mutilation, than other populations. So I'm seeking to answer a few questions to what extent Ghana has domesticated international regional human rights laws to protect women or prevent them from violence. Briefly, you should know that Ghana uses a hybrid legal system. So we recognize the common law, which is inherited from our colonial masters. Also, we have the constitution, and then we use the customary law, where there are instances where cases are settled through customary practices. Generally, though the constitution especially came after the ratification of CEDAW, CEDAW is not explicitly captured within the constitution. And that even goes to tell you that the Maputo Protocol is neither cited, because that even came way after the constitution was drafted. But our constitution does acknowledge that international human rights laws do play a great importance in protecting human rights. But then also the constitution, or Ghanaians, or Ghana as a whole, sees its constitution as supreme to all other laws, so far as it's not deviating from it. I will skip this to say that this presents the rights that are recognized under the constitution, political and civic rights, and also socio-economic rights under the various chapters. And in comparison to specific mentions, these can also be found correspondingly within the Constitution, the CEDAW, and the Maputo Protocol. Because of want of time, I would also skip other areas. But generally, if you're looking at Ghana as a whole, there are a lot of both legal and non-legal interventions to prevent violence against women. In terms of legal, we have the Domestic Violence Act, we also have the RTI Act, we have the Children's Act, we have Ghana Juvenile Justice Act, and a lot more. I'll skip briefly to what has been happening in terms of the legal space. So there are cases that have been cited the CEDAW, and I'll talk about the fact that though legal education or legal knowledge within Ghana on international human rights laws are limited, there are instances where CEDAW particularly has been cited to defend the rights of women. And in the case of the Republic versus Yabua, there was said that a child, even if a child does not report that he or she was raped, that does not show consent, and that the person is still liable to, to contempt of the law. And also in Gladys versus Stephen, women have women's right to property and even unpaid care work, which is recognized also in CEDAW, are acknowledged even after the dissolution of marriage. And there are multiple other cases as well. The recent case has to do with the Domestic Violence Fund, which is supposed to augment or serve as a facilitating tool for women who face violence. And then Pevi took the state to court, but then it was ruled that the Domestic Violence Fund needed to be funded or supplied with money, but that has not been done yet. And so he's seeking to go back to elections, go back to the courts. Now, looking at what has been reported, state reporting, and also shadow reports, you find out that Ghana cumulatively has not submitted anything on the Maputo Protocol, but it has largely reported, though not systemic as required, but has kept the reporting time, and then often does a cumulative reporting. There are about 4 CEDAW reports so far, and most of the reporting that the state highlights has to do with administrative, institutional, and a few legal awareness issues that it raises. Particularly with the CEDAW, one landmark victory had to do with the institutionalization of the Ministry of Women and Children's Affairs, which is currently the Ministry of Gender, Children and Social Protection. Then also the Female Genital Mutilation Amendment Act. We also have the Marriage, Customary, and Divorce Registration to protect women, and then the Mental Health Act, which protects women as well. Like I mentioned earlier, in most of these interventions, both legal and non-legal, the CEDAW is not explicitly mentioned, although it would, maybe when you look at the initial stage of the state reporting, they will mention CEDAW, but they would not, even if you look at other documents that are developed by the ministry, they would not mention the Maputo Protocol. That seems to say that comparatively, CEDAW is more recognized than the Maputo Protocol. But since there's no reporting on the Maputo Protocol, we cannot seem to say that most of the interventions that Ghana does is solely reliant on CEDAW, because Ghana is also a member to a lot of other international treaties. So in the extent of monitoring, these are the presentations that Ghana has made over the years, also leading to the establishment of the UN Security Council Resolution 1325 when it comes to violence against women in terms of peace and security. There have been national development plans and community sensitization, especially in terms of inhumane practices of chocolate and female genital mutilation as well. Then also the formation of gender desk officers to look at cases in most of the ministries, and then also in the Metropolitan District Assembly levels as well. I'm going to look at what has been the oversight role of the treaty monitoring bodies, what they have recommended, and what has been done and what has not been done. So you would see that I have a lot more to share, but I'm not going to speak on all of them for want of time. But I'll say that first of all, they've called for the abolishment and punishment of harmful practices like chocolate and the female genital mutilation, which I talked about. That has been extensively done, because when you look at the statistics, it's not as grievous as it were. And also the closure of some witches camp and integration of these people as well. What is left is to reintegrate children or girl child who happen to escort these witches, this alleged women as witches. And also the one recommendation was for Ghana to rectify the optional protocol on Convention Against Torture. And Ghana recently did that on October 2016. And there was also a recommendation for Ghana to pass the Right to Information Bill, which has been passed into law now. So we will say that yes, the comments and the recommendations at the CEDAW level are well taken care of, or Ghana considers them very important in its intervention going forward. Ghana was also urged to rectify the UN Convention on the Rights of Persons with Disability, and gladly Ghana has done that. There have been legal and paralegal education and strategic litigation that has been briefly done, and then also there's recommendation that there should be state funding and introduction of minimum operational guidelines for orphanages. That is being done. I know that there's a document. So this, I took part. I'm putting an asterisk on this because I took part in this process, but it's not out yet. So this is something that can be just it's just an asterisk, but it's underway. And then also there's complementary and traditional medicine and orthodox healthcare, and then gender training program within the Ghana Police Service, because one of the concerns of the CEDAW committee was that the Ghana Police Service, when you take a domestic violence case to them to look at it, first of all, they want to resort to settling it out of court or not applying legal guidelines to it. So this has been resolved, and then it's been included in the education or the curriculum of training. What has not been done is that concurrently or subsequent or multiple reports that come out from the Ministry of Gender, both in the media and state reporting, is that the ministry is less funded. And also critical is the Commission on Human Rights and Administrative Justice, which is supposed to serve as an oversight body or report on the situation of human rights issues in the country. Also, there's a limited elimination of polygamy, because I think that there are different marriage practices in Ghana, and if you do it the traditional way, the man has an opportunity to marry more. So if you happen to marry the traditional way, the man can always marry more, and in case of marital issues, the women tend to lose more because probably they'll lose their property, also their interest is not well catered for because of stigmatization. Then the woman will also have to suffer violence and stay in the marriage. So this is still pending as a recommendation. Also, there's no decriminalization of the consensual sex between adults. Let me hint that Ghana has a penalization for sodomy, but not about consensual sex. And currently there is a LGBTQI+ bill under consideration, and although other special mechanisms like special rapporteurs have condemned, and even their country versus to say that Ghana should not consider that this bill is still under consideration. As of the last 4 months, Parliament is still looking at this bill to pass it into law because there's a lot of mobilization around it. So this recommendation is also still being stifled. The last time the death penalty was executed was in 1993, but the death penalty is still in our books. Also, I would say that there's mobilization by civil society organizations, especially being led by Amnesty International, to get this law repealed and drawn out of the Constitution, but that is still happening. Then also critical is the fact that the right to housing is still not justified. So women tend to sometimes trade their body in exchange to have a right to housing. But this is a strong recommendation by UPR, that's investor peer reviews, and then the CEDAW committees as well, and even the WILDAF, which is the Women in Law and Development in Africa, which is a strong NGO in Ghana that has been doing a lot of shadow reports. This has been capitalized in many reports. Then also I'll talk of the fact that there are concerns by the African Commission on Human and People's Rights that Ghana has not submitted its status on, any reporting on human rights, and that should also extend to the status of women. And so this is not done. It's been over 20 years, and also there's no non-domestication of CEDAW international laws, especially when you look at Article 17 that talks about non-discrimination on all grounds. But it's not clear because in terms of same sex, then we have women who are perhaps falling within the LGBTQI. There's no clarity to that. Are you saying that they cannot, if you are saying they can be discriminated, but then also you do not recognize them? So that is also pending. Then also I talked about the fact that,
I'm sorry for interjecting, but you have 2 more minutes to wrap up. Thank you.
Right. So, okay. So I'll briefly go to what are the recommendations. Okay, I'll talk briefly about the challenges to that, and I put them in the political structure and social structure, and then economic. Economic has to do with poor budgeting or lack of gender-sensitive budgeting. Political structures have to do with lack of political will largely, and then social structures have to do with patriarchy, and then the fact that religious and cultural beliefs are being used to support violence against women. And also, pardon the typo, there is limited disaggregated data. So even when you want to intervene on issues concerning women, you cannot really do that absolutely. What is my paper recommending? A lot of issues. The fact that they need to be non-legal education, and then paralegal education as well. Also the inclusion of these treaties in legal education, because earlier I mentioned that knowledge of international human rights laws is very limited within the legal framework or even practice among judges. Also, there's need for social communication in terms of awareness raising, and also behavioral change communication, because you would notice from what I have said earlier that a lot of people endorse or normalize violence against women. So there's a need to stress on behavioral change communication. And also the fact that the CEDAW committee should be given that opportunity to give punitive measures to countries that do not take the recommendations that they talked about. So I will leave it here, and then if you have further questions, I would. Lastly, let me mention one very important point, which has to do with the development of treaty scorecards. That way, countries are able to know at what pedestal or what trajectory of impact they are making. I end here briefly, and then if you have questions, I would answer and show you the slides. Thank you.
Thank you very much, Eva. You may stop sharing your screen. And just to re-echo what Eva said, that after our last speaker, who will be talking to us as far as this session is concerned, we will have about 5 to 6 minutes to take questions from our participants. So please feel free to type your questions now in the question and answer chat box. Now, I will be moving to our next speaker, who is our last speaker for this, our second to the last speaker for this session. So her name is Devika Santosh-Nair, and Devika is a master's student, currently a master's student at the NorwegianCentre for Human Rights at the University of Oslo. And she has experience in human rights research and advocacy, and she has coordinated access to justice projects for marginalized communities and supported human rights litigation in India. She has worked at international and national human rights organizations such as Amnesty International, Human Rights Law Network, India, and the United Nations High Commissioner for Refugees. She's currently supporting the Norwegian Center for Human Rights in the capacity fund in the capacity of a project coordinator. For purposes of this seminar, Devika will be speaking to us about the need, and I think this issue was raised in the previous session, about the need for a bottom-up participatory approach in improving the domestic impact of the UN treaty system. Devika, you may take the floor, please.
Thank you, Felicio, and thank you to everyone who's joined us today. I'll just start by sharing my screen. Sorry about this, I'm not able to share my screen. Okay, perhaps I can just start without my presentation, and I'll just figure out how to continue sharing my screen. So basically, as we had already discussed in the seminar about different studies that have taken place on impact of the UN human rights treaties. And some of the studies were empirical studies on the impact. So as mentioned, Franz Enriger first study in 2002, as well as Beth Simmons and Ona Hathaway, etc., had multiple different studies on impact of the human rights treaties. But initially, there was not a lot of clarity as to the impact. But slowly, as we see more holistic studies have shown a clearer correlation between human rights treaty ratification and improvement of human rights standards. Some examples we've already seen in today's presentation during the seminar, as well as some examples that have been documented, like Colombian Constitution Court has based over 129 decisions based on the ICCPR, and there's been multiple different case studies and evidences of the UN treaty body mechanism being used, the general comments, inquiry, conclusions after inquiries, etc. But significantly, some points that kept repeating were issues of challenges related to the structural issues of the UN treaty body mechanisms, as well as the need for a domestic constituency. So I'll expand on these two issues, which paves way to the major argument of my presentation. So one of the issues which was already mentioned with by Professor Gentian as well was structural issues that are there within the treaty body mechanism, like struggling for state compliance, mandate constraints, bureaucracy, lack of equitable geographical representation in the bodies, problems of capacity, backlog, etc. And basically low take-up of the mechanism. So for this, these have not been ignored, as Professor Gentian mentioned, by the UN, and there has been UN treaty body strengthening efforts. For example, there's a UN General Assembly Resolution 68/269, which reviews the treaty body mechanism, and there are biannual reports that have to be submitted. And some of the latest reports have shown some improvements and harmonizing efforts. But we will see a proper review of this in the 77th UN General Assembly. So that was one part of common narrative that comes out of these studies. The second is for the need of, thank you so much, Farzo. Yeah, maybe you can just go to the fourth slide. Yeah, thank you. While these efforts have been continuing, there is another common line that comes out of these studies, which is the need for a domestic constituency. So what is this domestic constituency? So across studies, we have seen that there is a need, or one of the findings that the researchers who have done empirical studies find is the need for some kind of political liberalization or a reasonably active civil society to ensure that there is a positive impact. So these are two common lines that Professor De Burka has found out. Slide 4 is fine, so just the one previous. Yeah, thank you. So, so these are the two common lines. So while the first one is a more political issue, I have focused on the second one, which is a reasonably active domestic civil society. So as one of the factors that is important for measuring impact or showing more impact of the UN human rights treaties. So for instance, Eric Neumer in their research has shown that while he was researching on the human rights treaties, one of the condition was the strength of civil society and existence of domestic regimes in the state. And Beth Simmons, in her widely well-known research, has also spoken about the need for a certain domestic and legal traction of these human rights treaties. You can go to the next slide, please. Yeah, you can go to the next slide. So here is where, thank you, here's where civil society and national human rights institutions come into play. So there are multiple ways, as I think it was previously also mentioned during the seminar, how civil society, academics, etc. can play a role. Here I'm mostly focusing on civil society itself. So one is awareness raising, advocacy, litigation, and where it's needed, service delivery for further rights. So that is one role that civil society plays. Second is also from a monitoring perspective, as Professor Gentian also mentioned while answering a question about the role that civil society plays in terms of shadow reports and just not just submitting reports, but also the take up of these reports and concluding observations at the domestic level. So follow up of these outcomes, whether it is inquiry reports or just individual complaints and their observations. So civil society has a major role in that. Secondly, moving out of this description, there's also a role that civil society plays in ensuring the vernacularization of these norms. So it's not just about implementing UN treaty body mechanism results or observations, but it's also a vernacularization of these norms, which, as we all know, are an international, the UN human rights treaty bodies are still in an international forum. And how do you bring it back to the local level? And this is, so one of the example that's often quoted is of female genital mutilation, and how civil society has played a very, very important role in bringing the right CEDAW and other principles of women's rights into domestic use, and use those principles to work against practices such as FGM. And De Burka, who's a scholar in this, also mentions that this role that the civil society plays is not a unidimensional role. It's actually a much more revisionary and iterative function that they play in this whole human rights treaty mechanism. Like I said, it's not just about implementing, but also taking back issues. So probably there are issues that are still not addressed in the UN human rights treaty body mechanism, or which are not considered typically under, say, CEDAW or any of these conventions, but there could be coming out of these shadow reports and just general consultations with civil society, newer and more contemporary issues that can come out. Can we move on to the next slide? Thank you. So one of the treaties where this participatory approach has been used during the negotiations, as well as in the convention itself, is the Convention on the Rights of Persons with Disabilities. So one key aspect of this convention was the fact that it's a very rights-based approach at its core. So it was a move away from the medical model where persons with disabilities and the whole concept of their rights was seen as a very medical or an issue of the medical science. But slowly, this convention actually brought in that change of seeing it as a rights-based issue. And it included multiple different provisions such as substitution decision making, dignity, autonomy, meaningful participation, and as we know, reasonable accommodation, various other very, very progressive provisions. And it was a very widely taken up a convention signed when it was introduced itself. There were 82 signatories, etc. Now, fundamental to this paradigm shift, as per the literature, is the actual full and equal involvement of persons with disabilities. So very much from the negotiations till the end, civil society, disabled persons organizations, and persons with disability were involved along with the states in the negotiation. And these are also mentioned, this participatory approach is also present in the convention's provisions itself. We can go to the next slide. Yeah. So, for instance, Article 4.3 also talks about inclusion and consultation of persons with disability, children with disability, disability person organizations, and also focuses on, the convention also focuses on national level implementation and monitoring. So not just international implementation, but the convention also brought in national level implementation coded within the convention itself. So for instance, there are provision for focal points, national framework on disability, and in all of this, there is an explicit need to include civil society, persons with disability, and disability persons organizations. Even in the optional protocol, we see some innovative provisions of collective complaints, expertise from the disabled persons organizations, and there is a provision for a conference for state parties, including UN agencies and disabled persons organizations. But in all of this, one of the contexts that needs to be mentioned is that CRPD came at a time when there was a push that we already saw within the UN system for strengthening of its mechanism. So it was a parallel procedure. And maybe that is also one of the reasons why we see these innovative and participatory approach within the CRPD. Next slide, please. So impact of the CRPD, what has been this impact? Now, we can't, of course, attach direct links to all of this being just because of the participatory approach, but there are some things that can come out of it. For instance, there has been a good uptake of the CRPD, a drastic increase in the number of countries that have signed and ratified the the convention, as well as taken up more and more provisions on rights of persons with disabilities over time because of the convention. In a study that was done on how CRPD has been used in law and jurisprudence, the study came out to say that there were multiple instances of CRPD being used either to invalidate bad law or to interpret laws more broadly for the inclusion of persons with disability. So one example is in India, where in a case, despite not having any legislation that says so, the Bombay High Court, one of the constitutional courts in India, actually referred to reasonable accommodation as per the CRPD and read this duty into the Article 21, which is right to life of the Indian Constitution. So they read that into Article 21 and therefore gave an order for reasonable accommodation at a workplace for a person with disability. This is despite having any national instrument for that. Some impacts of civil society examples are there where civil society has actually caused an inclusion. So for instance, if you look at in an inquiry done by UK, there was an inquiry by the CRPD committee on UK spending reforms. And here it is said that one of the reasons why there was a strong and far-reaching observation of the committee by the CRPD committee was because of the incessant efforts of the disability movement, who submitted shadow reports, who advocated very strongly and kept at it, and that's why the inquiry resulted in such good reports. Secondly, also in India, we see an example of this, where India didn't have a legislation on disability rights, but after nationwide consultations with DPOs, many provisions were brought together, and a new legislation was formed, the Right to Persons with Disability Act of 2016, which embodies a lot of the principles of the CRPD. And this all came because of the nationwide consultations and movement by the disability persons organizations in the country. Yeah, we can move. So these were some examples of how CRPD work. There are some more examples, like in South Africa and Uganda, there have been studies done on how the voices of the disability persons organizations have actually not just been essential to the reforms, the constitutional reform, but also in a way, the authors have spoken about how now that they have made an inroad into bringing this into their constitution and their rights framework, they're also now paved a way for future reforms where they can again take part in ensuring its implementation. So it's become a dual step where involvement has resulted in much better position for civil society themselves. In Zambia, for example, where there was not much political will to put into place a monitoring framework, disability movement played a role to take forward the principles of CRPD through their own advocacy, movement, and grassroots level work. Another study on success factors of implementation of national disability strategies has shown that one of the key factors of a success for a national disability strategies has been the consultation process with persons with disabilities. So, I mean, how does all of this affect impact? Like, as we know, impact can be defined in very different ways, but this role that civil society plays to some extent is part of the broader interpretation of what impact is, as we see impact not just in the adoption of laws, and yeah, that is a big element, as we have discussed, that constitutional adoption or creating new laws, judicial acceptance, all of this is a big part, but this is also part of a bigger understanding of impact as seeing a change on the ground. And that's where civil society plays an additional role. Yeah, you can do it. Next slide, please. So what were the conclusions? Basically, this study that I had done shows that this role of civil society and how it is important in improving the impact of human rights treaties on the ground. And one of the important roles, or one of the important ways they have contributed, is part of this growing participatory dimension of treaty bodies in general. So this is argued by De Burka in her work, where she says that it's not only a causal theory for the effectiveness, but also a design for reform of the mechanism. So it's not just that they help in making sure that the treaty bodies are effective, but also this iterative role that civil society plays in bringing back issues to the UN Human Rights Treaty body level and the larger international fora, taking back issues and this multidimensional role that they play. So with faith in the UN treaty body mechanism process, which is happening at the UN level, where they're trying to find out how to better the treaty body mechanism, there's also a need to push for this role of civil society and find out more ways in which civil society can play a much bigger role, and acknowledge it and go ahead and find ways where this can be improved. So I can just move on to the last slide, where I just mentioned some of the further areas of research. So this was a very secondary resource-led research, but I believe that this idea can be taken forward to understand how civil society plays a role in this human rights treaty body mechanism impact. Some of the ideas were qualitative or quantitative analysis of the use of the treaty body, the human rights treaty language in advocacy and capacity building. So how is civil society? So studies to understand how civil society is using the human rights treaty language. Are they using it in their litigation, capacity building, etc.? Is there an uptake?
Devika, can you hear us? I think we lost you. We can't hear you, Devika. Okay, I guess you're trying to tell me that you have finished. Okay, I assume you can hear me, Devika, but we can't hear you. But thank you for the wonderful presentation, and I'm pretty sure we will take questions when we get to the question and answer session. So we already now have our next speaker, who is Jonas Sindani. Is a human rights lawyer and legal practitioner who has worked on advocacy and human rights as an advocacy and human rights officer for over 5 years within Congolese civil society organization and youth movement that are committed to the cause of peace, justice, the rule of law, and human rights in the DRC and the African Great Lakes region. Jonas holds a bachelor degree in law and is currently a master's student in the Human Rights and Democratization Master's Program at the Center for Human Rights, University of Pretoria. So this afternoon, Jonas will be taking us to the judiciary, and he will be discussing with us the role of UN human rights treaties in constitutional adjudication in Francophone Africa, with a focus on Benin. Jonas, you may take the floor, please.
Thank you very much, Faluso, for this generous presentation. My presentation of today is on the role of UN human rights treaties on constitutional adjudication of human rights, of course, in Francophone Africa. My interest is on Francophone Africa because myself, I'm a Francophone, so I beg you to apologize and to make effort with my diction. So, before going further with my presentation, I would like to make 4 preliminary observations. The first one is about the use of the concept Francophone countries. When I'm talking about Francophone countries, especially African Francophone countries, I'm referring to former French colonies, as well as former Belgian colonies, which are DRC, and Rwanda and Burundi. The second remark is that countries share the same legal tradition, which is the civil law tradition inherited from the colonization. And in this regard, they have a strong hierarchy of norms, which have at its apex the constitution. And then to some extent, in that legal tradition, the approach of sources of law is dogmatic and Kelsenian. The third observation is that countries have opted for a monist approach, and in this regard, the international law is simply part of the law of the land. So they have opted for the unity of the legal system, opposed to the dualist approach, which is opposed to legal order. And the last remark is that I'm focused on the Constitutional Court of Benin because first of its evidence of jurisprudential activity in terms of human rights adjudication, and secondly because the Constitutional Court of Benin has a unique mandate, a specific mandate in terms of protection and promotion of human rights, especially because of its direct accessibility by citizens. So I've made a quick PowerPoint in terms of goals, and my intervention will be articulated on 3 points. The first one, I will try to make an overview on the normative status of UN treaties in the domestic order. And secondly, I'll try to analyze the approach of the Benin Constitutional Court in applying UN treaties. And thirdly, I'll try to see why the Constitutional Court should rely on UNTB and the decision of the monitoring body. And to start with, when we are trying to assess the normative status of UN treaties in the legal system of African Francophone countries, the first thing we must note is that the status of human rights treaties is already regulated by African Constitution, I mean Francophone African Constitution, and they have a relevant provision on it is similar to the one of the French Constitution of 1950, especially on its Article 55, which is treaties or agreement duly ratified or approval shall, upon the publication, subject to the respect each agreement or treaty to its publication and to its application by the other party. And here I would like to make some observation. The first one is that the provision refers to the law, and here the law must be understood like an act of parliament, because the Constitutional Court of Benin, for example, has ruled that the ICCPR, for example, is not the provision of the ICCPR are not don't have a constitutional value, and therefore the ICCPR cannot prevail over the constitution. The second remark is that this provision doesn't make difference between international law sources. So the provision doesn't make difference between treaties in regard to the purpose or the object. So it seems like the provision apply both to international human rights treaties and other treaties. The third remark is that the provision put the condition of reciprocity, and we can't find in the constitution another provision which try to put a kind of light on this condition, but only the Constitution of Benin try to be clear on that provision and say that the condition of reciprocity doesn't apply for international human rights treaties. But however, the international jurisprudence has affirmed that the condition of reciprocity that doesn't apply for human rights treaties. And here, for example, the General Comment 24 of the ICCPR stated that the condition of reciprocity doesn't apply. The third observation is about the publication, because here the provisions state that the international treaties has superior value upon the publication, and the publication consists actually to make the treaty invocable against parties, and in the respect of this condition, the Constitutional Court of Benin refused to apply, for example, the CRC in 2002, when a petitioner alleged the best interest of a child based on the CRC, and the Constitutional Court of Benin stated that it cannot apply the CRC because it is not published on the official journal of Benin. And if you look at the time, is that the CRC was ratified by Benin in 1990, and the case was brought at the court in 2002, and that have a kind of negative impact in respect of in promotion of human rights, especially when the treaty is not published on time. And the last observation is that countries have chose for the monist approach, but the monism is not always monist, because when you look, for example, for some countries like Senegal, especially in the case Senabre, the Cour de Cassation ruled that it cannot apply the CAT, the Convention Against Torture, because Senegal had not taken legislative measures to internalize the CAT. And the same sound of bell is for Mali, especially in its initial report on the Convention on Right of Migrant Worker, and Mali stated that it didn't comply with its obligation because it didn't take it has not yet taken legislative measures to internalize, to domesticate the convention. And this is a little bit strange because in the monist approach, once the treaty is ratified, it became part of the law of the land. And until now, we are not aware, we are not informed on the situation where monist countries, African monist countries, took such kind of measures to domesticate human rights treaties. And finally, about the normative rank, the relevance here is that the higher the norm is ranked in the domestic order, the high is susceptible, especially to protect human rights, and the high and the most is susceptible to be invoked by party or the judge to support the claim. So, and actually, human rights treaties are UN human rights treaties are parts in the legal order of Benin of the bloc de constitutionnalité, the constitutional corpus, which is a set of rules which are constituted by especially international human rights treaties and organic laws, which allow or which provide a tool for constitutional interpretation. And that why in my second point, I will try to find out how or how and when the Constitutional Court of Benin relied on UN treaties, especially as interpretative tools of the Constitution. And the first thing I must say here is that the reliance of the Constitutional Court of Benin on UN treaties is very, very, very rare. But we have some case, especially the first case, the decision you can see on your screen. In this case, it was especially about the right to strike for members of military and police. And in this case, the court refers to the Convention on Social and Economic Rights, especially the Article 8, especially the Article 8, and the court ruled that the right to strike, and the court ruled that military and the right to strike of police and military can be restricted, can be subject to restriction. And in that case, especially the court found its motivation on the Article 8, paragraph 2 of the Convention on International Convention of Economic, Social, and Cultural Rights. In another decision is a recent decision of 2019 on the double degree of jurisdiction. The court especially referred on the ICCPR, especially the Article 14.5, and the rule that the double degree of jurisdiction is not a constitutional principle and therefore is not imposable to the constitutional judges. And in another decision of 2019, again, about human rights.
Okay, but you have 2 more minutes.
Thank you. And in a recent decision on asylum rights, the Constitutional Court as well referred on the convention, referred on the convention on the status of refugees. But there's reliance on human rights treaties are a little bit rare and formalistic. But the obstacle to invoke human rights treaties, especially during the adjudication before the Constitutional Court of Benin, is the problem of hierarchy of norm. Not only that problem, but the Constitution of Benin has a kind of 2 Bill of Rights. And we have first the Constitution Bill of Rights and the African Charter. And then when it comes to invoke human rights, the court prefer first to invoke the one in the Constitution, and secondly, it looks at the African Charter, and the UN treaties come at the third order of preference. The other problem is the attitude of judges. So they are not. It seems like they are not very familiar with the UN treaty system, because I've tried to look at some memorial of the lawyers, and the reliance to UN treaties is rare. And the other problem is the problem of coordination and harmonization of norms, because Benin is part to the multitude of norms, and when a claim is arise before the judge must look at that multitude of norms, which norm is more appropriate when a human rights violation is alleged. And in that kind, the Constitutional Court of Benin doesn't try to comply with all that multitude of norms, and it simply limits its reasoning, especially on the Constitution in which it's familiar. But in conclusion, for Luso, I think that the Constitutional Court of Benin has a lot of things to gain by relying especially on UN human rights treaties, because firstly, it's a kind of universalization of standard human rights protection, and it will lead to legitimate decision. And secondly, it will give to the court another interpretative method in interpretation of human rights, and especially it will strengthen its legitimacy, because every time the Constitutional Court will not comply with the UN treaty standards, it will open the road to petitioner to seize the UN treaties monitoring body, and the most decisions of the court are contested before other monitoring bodies. The reputation and the legitimacy of the Constitutional Court will suffer. Thank you very much for Luso, and looking forward if you have some question of clarification. Thank you.
Thank you. Thank you very much, Jonas, for your wonderful presentation. I think now we move to the question and answer session, and I'm just trying to look through the chat. I can't see any questions so far. Maybe our participant would like to raise their hands if you want to ask questions. Okay, I can't see any hands so far, but I think there is a general question from the previous session from an anonymous attendee who would like to know if the Center offers courses on training on United Nations Human Rights Treaty system, especially to non-academic participants. So at the moment, we do have a couple of short courses at the center that are open to non-academic participants, but we don't have these courses specifically on the human rights treaty system. Rather, they are sort of thematic in a sense. So we have short courses on children's rights, women's rights, sexual minorities, right of persons with disability, and we do take application from non-academic participants. So in that sense, we discuss the international human rights standards that are available, areas that I have mentioned. But I think we can always look at this and see if there's the need for the center as an institution to develop a course on with a specific focus on the UN Human Rights Treaty system. So if there are no questions in this regard, I suppose that means our speakers have been very articulate in their presentations and everything is well understood. We would then move to the next session, which is country level discussion on domestic impact of UN Human Rights Treaty system. So in this sense, we will be focusing on countries. And our first speaker for this session is Niels Alexander Aron, who is a master's student at the NorwegianCentre for Human Rights, University of Oslo. Niels has a background in political science from Freie Universität in Berlin, where he developed his interest for interdisciplinary research in human rights. His main interest in international law and refugee law, children's rights, minorities and indigenous people's rights. For this seminar, Niels will be focusing on the Convention on the Right of the Child and the enjoyment of children's rights in South Africa. And through this convention, Niels will be assessing the impact of the UN treaty bodies on the ground. Niels, you may take the floor, please.
Thank you very much for the introduction, Foluso. I hope you can hear me well. I will share my presentation now, and I hope it works. Let's see. Can you see the presentation? Okay.
Yes, we can.
Okay, so thank you very much for having me on this seminar, and thank you very much for the other presentations. I found them very, very insightful, and I hope I can add to the whole discourse of impact by presenting my article. It is currently being reviewed, and as you can see here, it is on impact in South Africa of the Committee on the Rights of the Child and the Convention. So first of all, I would like to point out my structure, my study background. Why did I do this study? My own little definition or my own little underlying value of impact. And then I'm looking at three spheres: constitutional law, court rulings, and policymaking. And before presenting kind of the conclusion, I will go into depth of how I assessed the 2016 concluding observations and the follow-up. I created an own follow-up more or less because the conventions on the rights of the child don't have an official follow-up procedure. And if there's the time, I will speak about general issues of state reporting mechanisms as well. Plenty of things have been said today, but I'm glad I could be part of this nonetheless. So the study background, why write about the CRC and South Africa? Well, the CRC is one of the most ratified human rights treaties, and it has, only the US has not ratified it, and even there it had impact. And I want to point out the case of Roper v. Simmons, a Supreme Court case, in which the court held that executing minors under the death penalty is unconstitutional, referring to the CRC. The CRC's provisions are quite fascinating to me, since they present an indivisible set of human rights for children. And this makes its provisions especially difficult as well, because are children right-bearing subjects in international and national law? That is the lowest point that you can see on the slide. And I chose South Africa for this research because South Africa's constitution is relatively recent, and it has some provisions that, as Professor Viljoen said earlier, could be seen as an impact or could be seen as an anchor. And I will come back to this constitution later. For now, it's relevant to explain what kind of underlying assumptions of impact have or can be found in my paper. So I started off with Professor Heinz and Professor Viljoen's impact study as well. Any influence that these treaties may have had in ensuring the realization of these norms. I applied a stricter scope for my own research, mostly due to this paper's smaller scale and capacity. So I looked at constitutional provisions, the court rulings that directly mention the convention, and changes of policies with reference to the monitoring mechanism, other dimension, or not necessarily to the monitoring mechanism, but to the convention. And these are the dimensions of impact on the ground. So for example, I leave out, I think I remember one example, human rights programs as yours at the University of Pretoria as a sphere of influence or impact. And this is a somewhat doctrinal approach. Neither do I speak about the impact of a treaty body or the CRC on public discourse, so in South African media or something similar. Yes, this would be called somewhat of a doctrinal approach. I have these prepared, these spheres, and I will start with the constitutional law, the 1996 South African Constitution. The temporal dimension somewhat allows the assumption that its authors were very familiar with the provisions of the CRC. Article 28 states that every child has an extensive list of rights. For example, a right to a name and a nationality from birth on, to basic nutrition and shelter, to protection in times of conflict, and to protection from exploitative labor practices, and many more. Article 28.2 refers directly to the CRC's best interest principle, which gives a strong legal basis to children's rights in South Africa. So this is, again, is it an anchor for impact, or is it the impact itself? I can see how this could be a follow-up question, kind of. Article 38, that is a different part, a procedural issue, does not mention children explicitly, but it is relatively clear to me, at least, that these provisions are designed to be operative for rights holders who might encounter difficulties, as one is due, ergo to children. So access to justice for children is kind of ensured through this article. And Article 39, Section B, obliges courts to consider international law and therefore the Convention on the Rights of the Child, for example, in relevant cases. And this leaves an active option for the South African courts and jurisprudence to be influenced or to have impact by international law. Secondly, I have two cases in the paper. The second case is Center for Child Law and Others, the Minister of Basic Education and others. But for this presentation, I would like to look at the governing body of this primary school, and the following. It's a significant amount of cases before different courts in South Africa referred directly or indirectly to the CRC. You could take that as a type of impact already, I think, but in this case, it's specifically visible, especially because it was the first time the right to education was connected in that way to the best interest principle in South African jurisprudence. So what happened is that a private landowner evicted a public school from its premises, and the Constitutional Court ruled in this appeal case that the High Court had failed to give consideration to the impact that the eviction order would have on the learners and their interests as children and pupils. So parts of the judgment resemble the CRC's wording almost exactly, especially Article 29 of the CRC, the right to education. And the second case, as I said, deals with the expulsion and exclusion of 37 pupils due to lack of national ID. So that's more of a non-discrimination child rights case than the right to education and right to property of this private company. The third dimension I looked at, or second, depending on how you count, is the policy, and I think I've seen it on Fulu's screen already, the reference to the Maintenance Act from 1998. In 1997, South Africa stated that they will base their National Plan of Action for Children and Youth on the Convention. And I pointed out in my paper these two acts. There's some more, but these are the most obvious ones, the Maintenance Act and the Domestic Violence Act, as you can see. Yes. So for my methodological and analytical frame, I looked at the 2016 concluding observations as the most recent one. I think one is due at the moment. And I cross-referenced these what they wrote in this state report in the concluding observations, excuse me, with other concluding observations of other treaty bodies. As you can see, the four that came out afterwards, the CAT, the CEDAW, the Committee on Economic, Social and Cultural Rights, and the CRPD. And I attempted to find references and therefore create a somewhat unofficial follow-up report if certain things came up. This has limits, but it was quite interesting to see what was mentioned. For example, the Committee Against Torture found both the legislation on corporal punishment and reasonable chastisement to be problematic. And their judgments from 2017 and 2019 declaring these practices unconstitutional as well. When I researched, the legislation was not harmonized yet. Both the CAT and the CRC mentioned that the corporal punishment of children has to be illegal under international and national law. Secondly, the CEDAW mentions the practice of ukuthwala. I hope I'm not mispronouncing it, ukuthwala completely, and virginity testing as FGM. Although they are all three prohibited, they are still practiced. So the CEDAW report states. And the CEDAW report also criticizes that virginity testing as a practice is only prohibited for children under 16. but all children below the age of under 18 are considered within the scope of the CRC. So the CEDAW committee makes a very concrete recommendation and urges the state to criminalize ukutwala and to prosecute all cases of harmful practices in South Africa. Thirdly, the Community on Economic, Social and Cultural Rights welcomed the raise in birth registrations from the 2016 concluding observations of the right of the child, although noting that the fees for late registration for newborn children may have negative and discriminatory impacts. So in 2018, they noticed that the impacts of this fee were negligible, so it was not enforced, and there was kind of a positive impact visible. Other areas of interest to both committees are the legislation found in South African Marriage Act from 1961 that sets different conditions for boys and girls under the age of 18. I have not found any progress or impact in that because the CRC keeps on mentioning it since the first state report, and there was no change so far, to my knowledge. And another positive development was the right to education, because the state funding was increased, although I found another document by the independent expert on the enjoyment of human rights by persons with albinism, and they noted in 2020 that general cuts to education budget were made, setting back the aforementioned progress or impact, and that is mainly due to the corona pandemic. And I think research would be necessary to evaluate that as well. Lastly, the CRPD's initial report refers to the CRC's recommendation from 2016 and urges the state to enact legislation giving full effect to the right to inclusive education for all children with albinism and the right to life. So that's a quite broad recommendation, more or less. I have here shortly the general issues of state reporting and mechanisms and monitoring. I think some things have been said. Concluding observations are not binding. The system relies to an ample extent on the goodwill of the parties. There's long delays. For example, the first report of South Africa, or the second report of South Africa, had 12 years of delay. That's a systemic issue, not only a South African issue. And the recommendations in concluding observations have been criticized for being too vague. I think that's not the case in South Africa, mostly because, as I said, some of the recommendations have been very, very concrete. Okay, so my concluding remarks. Children are being seen and increasingly heard. South Africa's unique situation, having a recent Bill of Rights and the provisions of this constitutional document indicate that the treaty had and still has influence. Yeah, the analysis of the monitoring mechanisms sheds light on what has not been done mainly. That's what I found. I have not found that much impact. I have rather found when there was no impact, which is rather sad, but it is as well a method of investigating these issues. And I have to address the own issues in this paper as well. So the narrow scope of impact and the focus on a quite positivist or doctrinal approach or understanding of the implications of a treaty body limit the understanding as well, because I'm sure there would be more to discover. And question like how many minors actually do enjoy the right to education and go to schools, or quantitative questions, cannot be answered through this kind of approach. And I would like to thank you very much for your attention. And yeah, I'm very happy to hear some questions as well. Thank you.
Thank you very much, Niels. You can stop sharing your screen now.
Yeah. How do I do that? Here.
Okay. Thank you very much. So we move on now to our next speaker, and she has actually spoken in the first session. So our next speaker is Ghana Ansari, who is a lawyer working in the field of international human rights law, gender equality, and Muslim and family law reform. And like I introduced her in the beginning, she finished her LLM from Harvard Law School on the Fulbright Scholarship, and she has worked at the Research Society of International Law and the NDU Center for International Law as a research associate. She currently works as an international advocacy program officer at Musawa, which is a global movement working towards equality and justice in the family. Our areas of interest include human rights law, gender equality, and constitutional law. So Faye will be talking to us about the domestic impact of UN human rights treaties in Pakistan. I think this is a general discussion on the treaties. Faye, you may take the floor, please.
Great, thank you so much, Filuso. I can start by sharing my screen. Just give me 1 second. Can you see the screen?
Yes, we can.
All right. Hello, everyone. Really happy to be here, and thank you so much for having me. I think I'm going to keep my presentation a bit shorter because I feel like a lot of things that I was considering talking about have already been discussed. The meaning of impact, how we measure it, all of that has largely already been discussed. So I'm going to keep that on the side and so go into sort of some specifics of how I see impact in Pakistan specifically. So yeah, let's get started. This is just a short summary of the ratification status of the country. We have ratified most of the main treaties, and the most recent one of those is the rights of persons with disabilities, but the rest have been ratified since quite a while. And again, the big question of measuring impact, how do we measure it? What do we do? How do we see that? Is it an anchor like Nils just mentioned, or something different? So all of that put aside, the presentation for this particular country, Pakistan, for me is going to be limited to laws, court judgments, and then a few other things that I want to discuss just generally. But this is the kind of research that I already did as part of the project that was discussed in the first session today. So I just wanted to highlight some of my findings for Pakistan for that. So in laws, we can, the way that I sort of looked at impact was maybe looking into the object and purpose of the treaty or of the law, or, its preamble, if an international treaty is mentioned there somewhere, if it was mentioned during any of the parliamentary debates that happened before that law was passed as a justification to have that law or not have it. That is also something that, I thought that was important. And then if there was any reference by any ministers or political party persons, I apologize for that, that is also something that I would count as impact. And then in terms of court judgments, the interesting thing about Pakistan is there's very few judgments that refer specifically to articles from these treaties or general recommendations or, specific positions that the committees have taken. But there is a general mention of these treaties as international obligations that you continue to see through judgments, especially if they have to justify any laws, particularly in relation to discrimination against women. So CEDAW has been a big part of that as well. And then we have NHRIs and civil society organizations that I'm going to talk about near the end of my presentation as well. So yes, the first example that I have here is the first example that I have here is the one very recent case of 2021 of the Islamabad High Court, and that was given by Justice Babar Sattar. And he, in his judgment, he held that the marriage of children under the age of 18 is unlawful, and the marriage contract is void from the start. So this is really a landmark judgment for the Islamabad High Court, given by the judge, because for just a little background on Pakistan, it is a federal country. So this is specifically a sort of a provincial issue. So we have provinces in the country, and then each province has the power to make its own laws in relation to specifically the minimum age of marriage for children as well. And Sindh, another province of the country, was the only one that already had 18 as the minimum age of marriage. But for other provinces, it wasn't there. So this judgment gave effect to that for the federal capital, Islamabad specifically. And the reason that they mentioned for it, at least one of them, was the UN CRC, Convention on the Rights of Child. And then I've highlighted a little bit of the extract from the treaty, which specifically from the judgment, which specifically mentions the treaty, and then why we need to sort of comply with it. And that's a main part of the mention of it. And then it goes on to quote specific articles, and it goes on to quote a lot of them, as I've mentioned here. And then the judgment also then talks about giving effect to international law, and what does Pakistani law say about that, which is just generally, if international law is not in conflict with domestic law, that existing domestic law, it needs to it is in conformity with international law, and Pakistan is under an obligation to comply with it. So that's sort of a summary of it. But yeah, that's a really good recent judgment which goes into the details of all of this, and a majority part of the judgment talks about this international treaty. And I feel like that is one of the greatest examples of domestic impact that we can see in our country. Another such example was also a recent one in 2020, and that was on the issue of a two-finger invasive test. So for rape cases, it was banned, thankfully, in 2020 on the basis of being in violation of international human rights obligations for Pakistan, and then also other reasons like being discriminatory, humiliating, lacking any scientific basis, and all of that. So again, I've put out a few extracts from those into the presentation on how the judge really nicely talks about all of the reasons why they need to ban this, but then specifically refers to CEDAW, which prohibits all forms of discrimination against women and everything. So this is also something that you can find a very direct impact of the treaty on this, at least in terms of providing that justification, because this has been an issue since quite a while, and there have been multiple NGOs working for this issue and working towards the prohibition of this test, but hadn't been successful. And I'm going to also talk about later on how NGOs also tend to use these concluding observations and treaties to push the government for reform. So yeah, that's the second one I have. And then we also have other judgments. Just very quickly, this one was from 2020 as well. This was on prison reforms. This is the example of what I was talking about in terms of just a general reference to treaties that courts make when they're trying to either direct the government to prescribe minimum standards for the treatment of prisoners, or even give specific directions. So this one is a more prescription of minimum standards for the treatment of prisoners, and pursuant to our obligations, human rights obligations under all of these conventions mentioned. So this was also something that really showed me that impact when I was researching for it. So yeah, and this is just like a little summary of other references to these articles and treaties that were mentioned in the judgments previously, but we don't need to go into much detail of all of these as well. Just a little indication of how courts and judges really do tend to use international obligations, and they don't really shy away from it. And whenever they're trying to justify or any change in the law or any progressive law, anything of that sort, we've seen these treaties being used, and that's really always great to see. In terms of laws, it always becomes tricky. I mean, we've heard so many things about how and why and what is the process by which we measure impact, and whether these human rights treaties even had any impact, or their reporting mechanisms had any impact. So it's always going to be very difficult to find out if a law was a direct result of any treaty. But again, like those who previously mentioned, you can sort of see that impact if a certain law was made right after a certain recommendation came out, or something of that sort. The one thing that I could directly see was in terms of, and and I've written this by mistake here, this is not the preamble, it was a statement of object and purpose that was submitted in addition to the actual law that was passed. So it was sort of a supplement to it, which explained why this law is being passed, and that in that this particular portion was mentioned on how this is why this law is being promulgated. And this was also promulgated after a rape case that really got a lot of media attention in the country, and a lot of laws were enacted after that against rape and for the protection of victims. So this is one of those, and it does refer to one of these treaties. So I do believe that these treaties do have an impact, their reporting mechanisms have an impact. It's just sort of hard to measure it because there's so many things happening at the same time, and so many so much lobbying happening at the same time, that you can't really pinpoint where and what led to that specific impact or change in the law or anything else. But yeah, the one other thing that I wanted to mention was generally NHRIs, independent human rights institutions, have been formed in the country, and they were formed after recommendations from these treaty body reporting mechanisms to form such a body. And what you see now is, for instance, for CEDAW specifically as well, there's a alternative reports that these independent institutions also submit in terms of what the state is doing in terms of compliance and what the state has done and hasn't done. So this is, sometimes in addition to the state party report that is given by the government itself. So this is sort of an independent version. It's supposed to reflect what the actual situation in the country is. So this is also something that I feel has had a great impact and has been a result of the treaty bodies and their reporting mechanisms, that this organization was formed in Pakistan, and then it continues to submit these sort of
apologies for interfering. You have about 2 minutes more.
Great. I will finish my presentation in 2 minutes. Thank you. So this is sort of the NCHR kind of work that they're doing. And then there's a bunch of organizations that, institutions that have developed under that. The Ministry of Human Rights also has its own cell that works on drafting these state party reports that conduct for every review. And that is also something that we continue to see in terms of these research officers also giving recommendations to the state to institute reform because of that. And just generally, I want to talk about civil society organizations and the impact that Devika already talked about a little bit. I, for instance, like I mentioned, work for Musawa, that is a Muslim family law reform organization working globally. And what we see in Pakistan, in addition to all the other countries that I'm working with, is that a lot of these national groups, advocacy groups, that is where these concluding observations and these treaties are being used the most. So they're using all of these treaties and concluding observations, and especially those follow-up issues that we're supposed to report on within 2 years as opposed to 4, for instance. These national advocacy groups are using all of these to pressure or, get the state to institute reforms. So that is something that we are continuing to see. And that is something that we are also supporting at the organization that I work at. We're doing follow-up projects with different national advocacy groups, and we're also going to do one with Pakistan. So these are the kind of things where I feel like we can see a lot of impact without having to see a direct impact on the change in the law. That will be an eventuality, but is not necessarily something of a starting point. So this is something that I feel should definitely be included in terms of measuring that impact. And if national advocacy organizations are submitting these shadow reports, building capacity, all of that is extremely important. So that brings me to the end of the presentation on Pakistan generally. But if you have any questions, I'm happy to answer those as well. Thank you.
Thank you very much, Faye, and thank you for wrapping up quickly. Let me just quickly apologize to our audience and our panelists as well. I see we're a little bit, we're running out of time, but thank you all for your patience, and we are trying to adjust the time so that we can finish as soon as possible. In that regards, now we will quickly move to our final presentation, which will be made by Brian Kibirango, who is a doctoral researcher at the Center for Human Rights. And Brian, in less than 10 minutes, you will quickly address us about insights from specific events surrounding Uganda's compliance with the ICCPR and Convention Against Torture. Brian, you may take the floor, please.
Thank you so much, Fuluso, and I do already note that we are fast spent on our time. I would like to begin with this quote that I'm going to contextualize. The police has a right to shoot and kill you when you reach a certain level of violence. Now, the above quote comes from Uganda's Minister of Security, who made it sometime in November 2020. Following mass killings of Ugandans across the country, about 50 people died, according to official reports, for participating in a protest after arrest of then presidential candidate Bobi Wine in the Eastern District, Luka. And what is clear from that quote is that the country's Ministry of Security was appropriating the status of right to a recourse which in law enforcement has to be taken as a measure of last resort. The circumstances obtaining in Uganda, and specifically on the fateful day, fell far short, in my view, of Ugandans who were shot dead, having been involved in acts that met the quite ambiguous level of, as the minister put it, a certain level of violence. I know this because on the fateful day I was particularly present physically at the Eastern Region District where Bobi Wine was arrested. We should note that the remarks were later to haunt the minister up to his death in August, which was untraditionally celebrated by Ugandans on social media. My understanding is that the reckless suggestion by the minister that shooting at demonstrators is a right takes away from it the guarantee of it simply being an exception. It thereby invites application of advanced force, which, for instance, shooting at people is, as a first port of call, even where it cannot be justified. And indeed, as we saw in uncontroverted videos that were circulated on social media, some of the deaths that occurred in the 7 November incident were really of people who had been going on with their business, standing by the roadside and then being shot at by personnel on aboard speeding patrols. There was, in many cases, no imminent threat either to the culprit security officers or even to the immediate public. Notably, Uganda is a party to the International Covenant on Civil and Political Rights, which was ratified, which it acceded to on 21st June 1995, and the Convention Against Torture that we acceded to on 3rd November 1986. The government of Uganda has over time, of course, made advancements in realizing its obligations, some of its obligations under the two instruments, the ICCPR and the CAT, in ways such as the enactment of relevant legislation, including, for instance, the 1995 Constitution with the Bill of Rights, Chapter 4. We have the Human Rights Enforcement Act, also adopted in 2019. We also have an Anti-Torture Act. We also have a number of judicial decisions, among other efforts that are seeking to promote a realization of those rights. But now let me take a somewhat different approach from my colleagues to reflect on the problematic of realization in Uganda of the rights guaranteed under the ICCPR and the CAT, particularly in the context of political competition. I will borrow from earlier remarks by Professor Ziberi that the project under which we are convening today is interested in dealing with some of the challenges of the 21st century. In more ways than one, the political question is a significant, if not a major challenge of the 21st century Uganda. Now, in that regard, I particularly focus on some of the events surrounding the recently concluded 2021 general elections, in which President Museveni has since successfully extended his now nearly 4-decade-long grip power. My assessment is that President Museveni is preoccupied with retention and survival of his regime, which has led to a situation where observance of relevant standards under the ICCPR and the CAT is relegated to when it is convenient for the state of Uganda, and particularly that being done actually to garnish the frailing legitimacy of that government. Again, I'm reminded in this case of the smart proverb from page 122 of Chinua Achebe's novel, Anthems of the Savannah, which says, "A man who answers every summons by the town crier will not plant corn in his fields." In my view, the proverb could pass for a philosophy guiding how the Ugandan government relates with the commitments that it adopted under the ICCPR and the CAT, especially during politically charged moments, such as the elections. The ruling National Resistance Movement government appears to have a predetermined position of not adhering to some of the summons made under the ICCPR and the CAT, and of course as human rights seeking actors, in order for it to successfully plant the seed of incumbents of a regime which, by the end of the current electoral term, which ends in 2026, will be only 10 years short of affording Mr. Museveni a jubilee-long reign over Uganda. Now, in specific reference to the 2021 general elections, the US Department of State associated the 2021 election season with gross violation of human rights, including arbitrary killings of opposition supporters, disenfranchisement and voter intimidation, harassment of the opposition, closure of media websites, lack of transparency and independence in the Electoral Commission. The periods before, it notes, during and after the elections were marked by a closing of political space, disappearance of political supporters, intimidation of journalists, and reports of widespread use of torture by security agencies. This is confirmed by the leading opposition candidate in that context, Bobi Wine, who both at the premiering of the documentary that has recently been premiered in Venice, Italy, titled Bobi Wine, the People's President, notes that, in Uganda, and as that documentary does chronicle, there are several atrocities that have been committed in order to sustain President Museveni's regime. He mentions, Bobi Wine, that, I must mention that in the film, not even 1% of the violence and oppression is documented, because this is centered around me, he himself, Bobi Wine, and the people that are around me. And you will agree with me, I do agree with him myself, that the people that are in the camera, that you, the international community, that everybody else outside Uganda has seen, actually represent the list of the oppression that goes on in Uganda. But yet, even that little that is able to come out into the public space, onto the internet, is horrifying enough for you and for the entire world. And so then there are also critical challenges relating to accountability for the violations that go on in Uganda. There is a book, Militarization and the Dilemma of Post-Colonial Statehood in Uganda, that Dr. Kabumba Businje, who is a public academic, commented.
Brian, I'm sorry, you have 1 minute more.
Okay.
You have 1 minute to wrap up.
All right.
Brian.
Thank you so much for so. Let me wrap up by observing that even as those violations are going on, the NRM government, or the government in power in Uganda, has adopted a sophisticated way in which it runs the project. It has the ability to be extremely authoritarian and militaristic, of course, violating civil rights under the ICCPR and the CAT, while at the same time having order appearances and trappings of a democracy. And the question I ask us all, how do we motivate a country like Uganda to be genuinely interested in implementing the ICCPR and the CAT aspects in relation to one, political competition, but also more broadly in respect to each observing its human rights obligations generally. My take is that we have to do all that is possible to ensure that our calls for observance of imperatives under international human rights law get to be taken into more seriously by states as binding obligations which must be upheld under any and all circumstances. I thank you.
Thank you very much, Brian. And once again, our apologies for staying this long. So in the interest of time, we will not be doing question and answer for this session, but I see there is a general, there's a comment here for the possibility of sharing the PowerPoint presentations. And we have to discuss this with our presenters because some of these presentations are work in progress that they intend to use elsewhere. So we will get back to you. The ones that are willing to share the PowerPoint presentation, when we receive from them, we will definitely then share with all of our participants. Thank you. Now we move to the concluding remarks for this session. And I would like to invite the director of the Norwegian Center for Human Rights, University of Oslo, Professor Bård Andresen, to give us some brief concluding remarks.
Thank you very much, Fuluso, and thanks to all participants for a very interesting session or seminar. Thank you in particular to Fuluso who has organized this with also with Frans Willion, of course, and the hidden voice behind us all. Very interesting program and a very interesting overall seminar. I feel there's so much competence that has been demonstrated by these PhD and master programs. Or researchers. So I'm actually very impressed by that. I also observe that there is a lot of interest in different disciplines in addressing this issue of treaty body impact. So there is a balance between legal approaches and social science approaches, which is very, very important in this field, indeed. And it also calls for, many of you are carrying out case studies. But this is a field which is also calling for comparative analysis. So keep that in mind. And the database that the South African Center is developing gives a lot of opportunity for that in the years ahead. My main observation is that the discussion about impact is very important, and it will not go away. It has been there for a long time, and it's something I think we'll have to struggle with and work with as we move along. I don't think we ever can solve it fully. But you have made some very important observations in your research already that I think is worth reflecting on. I think that the point of departure with Gentian, when he said that we have to be cautious about making causation analysis, we are talking about correlations, and plausible impact is perhaps that kind of modest approach that often can work out. We have to be we are struggling with this problem of attribution, and we have to be somewhat modest about how far we take our conclusions. As long as we are aware of that, and as long as we are explicit of that, that is fully okay. We also have to talk about impact on individual and systemic level, as some of you have referred to, and there are different types of impact. I think that's something that you can explore even further. There are legal impact, of course, how treaty bodies impact on domestic law. There is social impact, how domestic or treaty bodies and conventions are impacting on social norms, not least in the field of gender. And there are governance or political institutional impact, where treaty bodies, practices, and conventions can have an impact on political institutions and the right to association, the right freedom of speech, and other civil and political rights. Many of these have been addressed by you. I heard much of this in Benson's Shagai's presentation, very interesting one on Kenya and the constitution of Kenya. I heard it in Niels Avon's presentation, The Rights of the Child, and Ferhansani, discussion of Pakistan, and also the discussion on Benin by Jonas Sindai. These all, in my view, talks about legal impact. I don't have time to go into much detail to justify that, but that was something that came to my mind. And legal impact there can be legal impact without necessarily closing what we call the implementation gap. That is, improving social reality on the ground. But law can have its own function as it is without necessarily having great impact on the ground. But it is still important. And then Julian Onensen talked about the impact of education and awareness raising, which is another very important part of our discourse, in a sense. We are discussing at the Norwegian Centre for Human Rights how we can get journalists and the media better into this work, which is, in my view, very, very important, and nobody has actually mentioned that so far. Building capacity for impact as it is. And Devila Nair, she talks about this bottom-up participatory and civil society approach, which is impact by civil society on legal treaty bodies' work. And that is also an important impact dimension. So I would like to end by just saying and go back to Julia's point that she raised about the impact that academics can have in this field, because we are academics and we try to make our contribution one way or the other. She talks about spreading knowledge on being advisors, being members of committees, and to be critics of the work that the treaty bodies are doing as researchers, and engage in parallel reporting as examples. And all of these are very important ways that we as academic community, through our academic work and research, can impact on the work of treaty bodies, learn from the treaty bodies, but also have an impact on the work that is being done in order to make them better and perform better and develop law in better ways. So these are some, because we have little time, I have to limit myself. These are some of the observations I made after a day, which or 2.5 hours, which 3 hours now, which I feel was very well very well spent. So thank you very much to all of you for having done excellent preparations and presentations. So thank you very much. And I look forward to the collaboration with the Centre for Human Rights in Pretoria in the years ahead.
Thank you very much, Prof. Bad, for those succinct summary of everything that we've had today. I think that's a very tough task to put all of this together in one thought. Thank you very much for that. And I think from my end, I would like to just stand on the existing shoulder of Prof. Bad and say that the question of impact is a question that will continue to linger on, like he has said. And that's why we will have more of this seminar, and we will have next year, we will have more of this. We'll have conversation from different perspectives, like some of the issues that Prof. Bad has raised, from legal, social, governance, and different form of impact. And we will definitely be exploring this as we move forward on this project. I would like to thank everyone who has participated in this seminar. I would like to thank all of our panelists for their preparation, all of the emails. Thank you very much for putting in very great effort. Thank you to the two directors of the Norwegian Centre for Human Rights and the Pretoria Centre for Human Rights. And a big thank you as well to Professor Gentian Zuberi for his input on this. And I would like to thank everyone that has also helped with organizing this, everyone in the litigation and implementation unit at the Center for Human Rights and the communications unit of the Center for Human Rights for helping to put all of this together. Once again, thank you for your time. It's been a very long hour, but it's been well spent, as said by Prof. Bad, and we hope to see you sometimes for the next edition of this seminar. Thank you. Bye.